Hi guys, this is Erica from Gokche Capital. Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. The other day I got off a call with someone who was interested in selling their vacant land. Now, the seller had bought the property with her deceased sister and was very surprised to learn that she would need to go through the ancillary probate process in the county where the property is located before we could purchase it. Now, what is ancillary probate and how could she have avoided this? I'll cover these items along with the other top things you need to know about probate in this video. But first, what is probate? Well, probate is a legal process, and it is the process by which a will is reviewed and determined by the probate court to ensure that it is valid and authentic and that all the heirs are correctly designated. And having said this, probate also occurs when there is no will available, in which case distribution of assets is often determined based on the state's probate code. Either way, there is a person who is designated to administer the estate. When there is a will involved, that person is called an executor. When there's no will, the person is usually called an administrator. You may also see this person called the personal representative of the estate. And if you have been designated executor, administrator, or personal representative, you will be responsible for overseeing the whole probate process and for distributing the estate's assets. How this works varies from state to state since every state has its own probate laws. But generally, you will first need to find an estate or probate attorney and have them file a petition with the local court office in the county where the deceased lived. At the end of this process, the court will give you a document, usually called a letter testamentary, which gives you the right to act as the executor and distribute assets according to the stipulations in the will. Now, when there's no will, you'll get a letter of administration giving you authority to act as administrator of the estate, and the court will also determine who the heirs of all assets should be, based again on the state's probate code. As administrator or executor, you will then need to pay any bills and taxes owed out of estate funds prior to distributing the assets. Once these obligations have been met, you can then transfer the assets to the designated beneficiaries. So as you can imagine, this is a long process, and any beneficiary should expect that it could take several months to a year to receive the assets from the estate. But let's return to our opening story. I mentioned that we were not able to purchase the property from our potential seller because the property had not gone through ancillary probate. So what does this mean? Well, if the deceased owned property in a different state or county from where they live, it is often not enough to simply open probate in the county where the deceased lived. A smaller ancillary probate process needs to occur in the county where the property is located in order to ensure that title transfers cleanly. Now, this process is usually far more simple than a full probate proceeding and may often just involve submitting a form along with the court stamp probate document from the main probate process. And the reason that this is done is to ensure that when a title company later researches the chain of title, they can see evidence that the deceased passed away and that the correct heir was given the property. Therefore, if you are an executor or administrator of an estate, be sure to look into ancillary probate. And I'll also note here that I've heard some potential sellers tell me that they were advised by their legal counsel that they did not need to go through ancillary probate. This may be because it is not, strictly speaking, a legal requirement, or it may not be necessary in the state where your lawyer is located. So this is why if you are dealing with investment property in a different state, it's a good idea not only to discuss with your estate attorney, but also with a title company local to the property in question. Number 4, probate may be necessary if a deceased person is listed on the deed. This is true even if one or more additional owners are still living. This is another mistake that I often see landowners make. If 2 or more people acquire property together, often the assumption is that if one of these owners passes away, the other will automatically inherit the property. But this is not always true. Depending on how title was acquired and the laws of the state and the relationship between the 2 owners, probate may very well be required to pass title onto the surviving owner cleanly. So again, if you find yourself in a situation such as this, it's a good idea to speak with a title company that is local to the property in question to ensure that title is fully and cleanly transferred to you upon the passing of your co-owner. Number 5, a surviving spouse may also need to go through probate to inherit property. This again depends on state law, that is whether the property is in a community property state or not, and whether property was held in joint tenancy. And you can check the kind of tenancy that you acquired title under by looking at language in the deed. If the deed says joint tenants with right of survivorship, then probate is usually not required. But it's always a good idea to check with the title company that is local to the property in question. So having said all this, how do you ensure that your heirs or your co-owners do not have to go through probate in the event that you pass away? Well, the most common way to bypass probate is to hold property in a trust. The other way that you can help avoid probate, at least for your co-owners, is to ensure again that you acquire property as joint tenants with right of survivorship. And as you are buying a parcel of land, speak with your lawyer about this and make sure that the correct language is included on the deed. Now, do you have any stories about probate or inheriting property? Let us know in the comments. Did you like this video? You're going to love our Gokche Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokchecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokchecapital.com/listings. Finally, don't hesitate to reach out with any questions. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.